Picture this scene. You're 74 years old. You have worked since you were 17. You paid your mortgage for 30 years. You raised 2 kids. You buried a spouse. And after all of that, you have $200,000 sitting in a savings account at your local bank. That is the sum total of your financial survival kit. One Tuesday afternoon, you drive to the bank. You sit down with a 26-year-old bank teller named Brittany, who has been on the job for 9 months. Brittany smiles and says, "We can add your daughter to the account. That way, if anything happens to you, she can write checks and keep the lights on." You sign a form. Brittany notarizes it. Your daughter's name and social security number are now on the signature card of your life savings account. You walk out feeling like a genius. Free estate planning. No lawyer, no trust, no $1,000 retainer. I need you to hear me right now. What you actually did was hand the keys to your financial vault directly to your daughter's creditors, her future ex-husband, and the IRS. You did not add your daughter to your account. You made her a legal co-owner of every dollar in that account. The moment her name hit that signature card, every creditor she has, every lawsuit she will ever face, every divorce she will ever endure, now has a legal claim to your money. Not her money, your money. The money you skipped vacations and drove used cars and clipped coupons for 40 years to save. That money is now in the legal crosshairs of people you have never met. This is not theory. This is happening right now in 2026 in every county courthouse in this country. Seniors are losing their retirement savings because a bank teller who earns $15 an hour told them to just add your kid to the account. That bank teller did not warn you about joint tenancy liability. That bank teller did not explain that under the Uniform Probate Code and every state's creditor attachment law, a co-owner's interest in a joint account is a seizable asset. That bank teller did not mention that your daughter's future ex-husband's divorce attorney will run a financial discovery sweep and find your $200,000 under your daughter's social security number in about 45 seconds. I see the wreckage of this advice every single day. 70-year-old widows watching a judge freeze their savings because their son got sued. Retired school teachers who cannot pay for medication because their daughter filed for bankruptcy, and the Chapter 7 trustee locked down every account with her name on it. That is what this video is about. I'm going to rip the mask off the joint custody trap. I am going to show you dollar by dollar how your child's creditors can legally drain your retirement account. I am going to walk you through 3 real-world scenarios that will make your stomach turn. And then I'm going to hand you the exact legal blueprint that the top 1% uses to give their children full access to help them without exposing a single penny to anyone else's liabilities. This strategy costs about $500 and saves families hundreds of thousands. The wealthy have known about it for decades. The middle class has been getting slaughtered because nobody told them it existed. Let me explain why this is so dangerous. When you add your adult child to your bank account, the bank creates what is called a joint tenancy with right of survivorship. That phrase sounds harmless. It is not. It is one of the most powerful legal ownership structures in American property law, and it means every person whose name is on that account is a full equal legal owner of the entire balance. Not a partial owner, not a helper, not an authorized signer, a legal owner. The law does not care that you deposited 100% of the money. The law does not care that your daughter has never deposited a single dime. The law looks at the signature card, sees 2 names, and says, this asset belongs to both of these people equally. You worked for 50 years. You saved $200,000. You put your daughter's name on the account so she could help you pay bills. And the legal system now treats that money as if your daughter earned half of it. She did not. But the law does not care what is fair. The law cares what is documented. Here is where the nightmare begins. Because your daughter is a legal owner, that money is now part of her financial profile. It shows up when creditors run asset searches. It shows up when divorce attorneys file financial discovery motions. It shows up when the IRS runs a tax lien search. It shows up when a bankruptcy trustee does a forensic sweep of every account attached to her social security number. Your $200,000 is now visible, accessible, and legally attachable by anyone who has a claim against your daughter. Let me walk you through exactly how this destroys families, and I'm going to use 3 scenarios that I see play out in courtrooms across this country. I call these the 3 horsemen of the joint account apocalypse, and every single one of them is happening right now to real families with real money. Scenario number 1, the car accident. Meet David. David is 72 years old. He is a retired electrician from Columbus, Ohio. He has $250,000 in a joint savings account with his son, Mark, who is 44. David added Mark to the account 3 years ago because David had a knee replacement and wanted Mark to be able to pay bills during recovery. Mark is a good son. Mark has never taken a dime from that account. One rainy evening in October, Mark is driving home from work. He runs a red light. He broadsides a minivan carrying a mother and 2 children. The mother suffers a spinal injury. The medical bills exceed $1,000. Mark's auto insurance policy has a liability limit of $300,000. The insurance pays out the policy maximum, and the plaintiff's attorney looks at Mark and says, "You still owe us $700,000. Let's see what you have." The attorney files a post-judgment asset search. Within 72 hours, that attorney finds the joint savings account with $250,000 in it. Mark's name is on the account. The attorney files a writ of execution. The court issues an order freezing the account. David cannot withdraw a single dollar. David cannot pay his rent. David cannot buy his medication. David cannot pay his electric bill. The account is frozen solid while the court determines how much of it belongs to Mark and how much belongs to David. Now, here's the part that should make you furious. In Ohio, the legal presumption for joint accounts is that each owner has an equal share. That means the court starts with the assumption that $125,000 of that account belongs to Mark. The plaintiff's attorney is entitled to attach Mark's share to satisfy the judgment. David has to hire a lawyer, go to court, and prove with documentation that he deposited 100% of that money. If David kept meticulous records, bank statements going back years, deposit slips, tax returns showing the income source, he might be able to claw back some of that money. If David is like most 72-year-olds and threw away his bank statements after a year, he is going to lose a devastating amount of his retirement savings to pay for his son's car accident. This is not a hypothetical. This is Ohio Revised Code Section 2329-66. This is how creditor attachment works in the state of Ohio in 2026. And Ohio is not special. Florida has a nearly identical framework under Florida statute, Section 655.79. And California follows the same general presumption under California Probate Code, Section 5305. 3 states, 3 different legal codes, one identical result. Your money gets frozen, your money gets attached, and you spend the next 18 months in court trying to prove what should have been obvious from the start, that it was your money all along. Scenario number 2, the divorce. Meet Patricia. Patricia is 68 years old. She is a retired nurse from Jacksonville, Florida. She has $180,000 in a joint account with her daughter, Lisa, who is 41. Lisa is married to a man named Kevin. Kevin is not a great guy, but that is not the point. The point is that Lisa and Kevin are about to go through one of the most vicious divorces in Duval County history. Kevin's divorce attorney is sharp. Kevin's attorney files a standard financial discovery motion, which requires Lisa to disclose every asset she owns or co-owns. Lisa has to list the joint account. She has no choice. Failure to disclose is contempt of court, which means jail time. So Lisa discloses the joint account with $180,000. Kevin's attorney sees that number and his eyes light up like a slot machine. Under Florida's equitable distribution statute, Florida Statute Section 61.075, all marital and joint assets are subject to division. Kevin's attorney argues that Lisa's share of the joint account is a marital asset. The family court judge freezes the account pending the divorce proceedings. Patricia cannot touch her own money. She cannot pay her mortgage. She cannot pay her supplemental Medicare premium. She cannot buy groceries. Her $180,000 is sitting in a frozen account while her daughter's divorce grinds through the Florida family court system, which takes an average of 12 to 18 months. And here is the kicker that makes this truly devastating. Even if Patricia eventually proves that she deposited all of the money, she has spent 12 to 18 months without access to her life savings. She has missed mortgage payments. She has accrued late fees. She has damaged her credit score. She may have had to borrow money from friends or family just to survive. The damage is done long before the court ever rules in her favor. Scenario number 3, the bankruptcy. Meet Robert. Robert is 75 years old. He is a retired postal worker from Sacramento, California. He has $200,000 in a joint account with his son, Michael, who is 47. Michael owns a small restaurant. The restaurant has been struggling since 2024. In early 2026, Michael cannot make his lease payments, cannot pay his vendors, and cannot service his small business loan. Michael files for 7 bankruptcy. The moment Michael files that bankruptcy petition, an automatic stay goes into effect, and a bankruptcy trustee is appointed. The trustee's job is simple: find every asset Michael owns and liquidate it to pay Michael's creditors. The trustee runs a comprehensive asset search. The trustee finds the joint savings account with $200,000 under Michael's Social Security number. The trustee files a motion to include the joint account in the bankruptcy estate. Under 11 U.S.C. Section 541, the bankruptcy estate includes all legal and equitable interests of the debtor and property. Michael is a legal co-owner of that joint account. His interest in the account is property of the bankruptcy estate. Robert now has to hire a bankruptcy attorney, file an adversary proceeding, and prove to a federal bankruptcy judge that every dollar in that account came from Robert's earnings, Robert's pension, and Robert's Social Security. In California, the burden of proof is on Robert to demonstrate that the funds are not Michael's. If Robert cannot produce years of bank statements, deposit records, and income documentation, the trustee will seize up to $100,000 of that account, which is Michael's presumed 50% share, and distribute it to Michael's business creditors. Robert saved that money over 30 years as a postal worker. He never missed a shift. He never called in sick. He sacrificed so his family could have a safety net. And now a bankruptcy trustee is liquidating his savings to pay the bills of a restaurant Robert never ate at, never invested in, and never had anything to do with. This is what happens when you take the shortcut. This is what the bank teller did not tell you. Now, take a deep breath. Listen to me very carefully. You cannot rely on hope as a financial strategy. If your child's name is on your bank accounts, your entire life's work is vulnerable right this second. Okay, let me get back to the math of how a power of attorney shields your money, because this is where everything changes. I have shown you the 3 ways your money gets destroyed. The lawsuit, the divorce, the bankruptcy. 3 different legal mechanisms, 3 different courtrooms, 3 different judges, 1 identical outcome. Your retirement savings frozen, attached, and potentially seized because your child's name was on the account. Now, I'm going to show you the strategy that prevents all 3 of these scenarios, every single one. And it costs a fraction of what you would lose if you did nothing. The strategy is called legal isolation, and it is built on 2 documents that the wealthiest families in America have used for generations. Document number 1 is a revocable living trust. Document number 2 is a durable power of attorney. Together, these 2 documents give your child 100% of the access they need to help you manage your money while giving your child's creditors 0% access to your assets. Let me explain exactly how each one works, because the details matter enormously. A revocable living trust is a legal entity that holds your assets. You create the trust, you are the trustee, which means you control everything. You are the beneficiary, which means you receive all the income and benefits from the assets. You can add money, withdraw money, close accounts, open accounts, do anything you want. For all practical purposes, the trust is you. But here is the critical difference. The assets inside the trust are titled in the name of the trust, not in your personal name, and not in your child's name. Your savings account goes from being titled Robert and Michael, joint tenants with right of survivorship, to being titled the Robert Family Revocable Living Trust. Robert controls the trust. Robert benefits from the trust. But Michael's name is nowhere on the account. Michael's social security number is nowhere on the account. When Michael's bankruptcy trustee runs an asset search, your $200,000 is invisible. It does not appear on Michael's financial profile. It cannot be attached to Michael's debts. It cannot be frozen by Michael's divorce court. It cannot be seized by Michael's lawsuit judgment. The money is legally isolated from every risk in Michael's life. But wait, you say, the whole reason I added Michael to the account was so he could help me pay bills if I got sick. How does Michael help me if his name is not on the account? This is where document number 2 comes in, and this is the part that should make you want to stand up and cheer. A durable power of attorney is a legal document in which you, the principal, appoint another person, your agent, to act on your behalf regarding financial matters. You name Michael as your agent under a durable power of attorney. Michael walks into the bank with the POA document. The bank puts a copy on file. From that moment forward, Michael can do everything a joint owner could do. He can write checks, he can make withdrawals, he can pay your mortgage, your electric bill, your medical bills, and your Medicare premiums. He can manage your finances as if he were you. But he is not an owner. He is an agent. And that distinction is the most important legal distinction in asset protection. Let me explain why that distinction matters. When a creditor goes after your child, they can only attach assets your child owns. A power of attorney is not an ownership interest. It is an agency relationship. Think of it like hiring a property manager for a rental house. The manager has the keys, collects rent, calls the plumber, pays the electric bill, but the manager does not own the house. If the manager gets sued, the plaintiff cannot take the house. That is exactly how a durable power of attorney works. Michael is the manager of your money. Michael is not the owner of your money. Michael's bankruptcy trustee cannot seize money that Michael does not own. Michael's divorce court cannot divide money that is not a marital asset. Michael's car accident plaintiff cannot attach money that does not belong to Michael. Your $200,000 sits safely inside your trust, managed by Michael when you need help, but completely shielded from every creditor, every lawsuit, and every divorce that Michael will ever face. Let me run the numbers so you can see the math of what this strategy saves you. I'm going to replay each of our 3 scenarios with the legal isolation strategy in place. Scenario 1, replay. David, 72, retired electrician, $250,000. This time the account is titled in the name of the David Family Revocable Living Trust. Mark has a durable power of attorney. Mark causes the same car accident, the same $1 million judgment, the same post-judgment asset search. The plaintiff's attorney runs the search under Mark's social security number. The joint account does not appear. The attorney finds Mark's personal checking account with $6,000 in it. That is all Mark has in his own name. The attorney cannot touch David's trust account because Mark does not own it. David's $250,000 is completely secure. David continues paying his rent, buying his medication, and living his life without a single disruption. Scenario 2, replay. Patricia, 68, retired nurse, $180,000. The account is now in the Patricia Family Revocable Living Trust. Lisa has a durable power of attorney. Lisa and Kevin go through the same vicious divorce. Kevin's attorney files the same financial discovery motion. Lisa discloses her personal assets. The trust account does not appear on Lisa's financial disclosure because Lisa does not own it. Lisa is an agent, not an owner. Kevin's attorney has no legal basis to freeze, attach, or divide the trust account. Patricia's $180,000 is untouched. Patricia continues paying her mortgage and her Medicare premiums without missing a single payment. Scenario 3, replay. Robert, 75, retired postal worker, $200,000. The account is in the Robert Family Revocable Living Trust. Michael has a durable power of attorney. Michael's restaurant fails. Michael files Chapter 7 bankruptcy. The trustee runs the comprehensive asset search. The trust account does not appear under Michael's Social Security number. Michael is an agent on the account, not an owner. Under 11 U.S.C. Section 541, only property that the debtor has a legal or equitable interest in becomes part of the bankruptcy estate. An agency relationship under a power of attorney is not a legal or equitable interest in property. The trustee cannot touch Robert's $200,000. Robert's retirement is 100% intact. 3 scenarios, 3 catastrophic outcomes with a joint account, 3 perfectly protected outcomes with a trust and a power of attorney. Same families, same crises, completely different results. The only difference is the legal structure, and that legal structure costs a fraction of what these families would have lost. Let me talk about cost. A basic revocable living trust costs between $500 and $2,000 depending on your state. A durable power of attorney typically costs between $100 and $300. Many attorneys draft both as a comprehensive estate planning package for $800 to $1,500 total. Now do the math against the alternative. David lost $125,000 because he trying to save a $500 attorney fee. Patricia lost access to her $180,000 for 18 months, accrued thousands in late fees, and destroyed her credit score because she did not want to spend a $1,000. Robert lost up to $100,000 to a bankruptcy trustee because he thought adding Michael to the account was the same thing as an estate plan. You spend a $1,000 now, or you lose $100,000 later. That is not a financial decision. That is a survival decision. Now, I need to talk about the word durable and durable power of attorney because this is a detail that trips people up, and it is critically important. A regular power of attorney terminates if you become mentally incapacitated. That means if you have a stroke, develop dementia, or suffer a traumatic brain injury, a regular POA becomes worthless at the exact moment you need it most. A durable power of attorney specifically states that the agent's authority survives the principal's incapacity. This is the entire reason you're setting this up. You want your child to be able to manage your finances if you cannot manage them yourself. If the POA is not durable, it evaporates the moment you become incapacitated, and your family has to go to probate court and petition for a conservatorship, which costs $5,000 and takes months. The word durable is not optional. It is the whole point. I also need to address a question I get constantly. Can I just make my child an authorized signer instead of a joint owner? Fair question. An authorized signer can make transactions, but does not have an ownership interest. In theory, this should protect the account from the signer's creditors. But the legal protections for authorized signers vary wildly by state and by the specific language of the bank's signature card. Some courts have ruled that an authorized signer with unrestricted access has a de facto interest that creditors can attach. The legal precedent is inconsistent. A durable power of attorney, by contrast, has centuries of established legal precedent clearly defining the agent's role as a fiduciary, not an owner. The distinction is crystal clear, universally recognized, and battle-tested in every state court system. Do not gamble on the authorized signer approach when the durable POA provides ironclad protection. Let me talk about Medicaid, because this is another dimension of the joint account trap that almost nobody discusses. About 70% of Americans over 65 will need some form of long-term care. Nursing home costs can exceed $10,000 per month. To qualify for Medicaid, a single applicant in most states can have no more than $2,000 in countable assets. When you add your child to your bank account, you create a nightmare for Medicaid eligibility. When you need to remove your child's name to get below the asset limit, Medicaid may treat that removal as a transfer of assets. Under the look-back rules, any transfer within 60 months of applying triggers a penalty period during which you are ineligible for coverage. The state Medicaid agency will determine that removing your child's name constituted a transfer of their ownership share and impose a penalty that could leave you without nursing home coverage for months. If your money had been in a trust from the beginning, there is no joint owner to remove, no transfer to trigger a penalty. Your assets are in your trust, titled in your name, And when you need to spend down for Medicaid, you do it cleanly without the legal ambiguity a joint account creates. I want to talk about the emotional manipulation that banks use to make joint accounts seem like the obvious choice. When you walk into a bank and say, "I want my daughter to be able to help me with my finances," the teller's first response is always, "Let's add her to the account." Every single time. Why? Because it is free. It takes 5 minutes. The teller checks a box on their daily productivity report. The bank gets a second depositor, reducing the statistical likelihood of the account being closed. The bank makes zero revenue by telling you to see an estate planning attorney. The bank makes zero revenue by explaining joint tenancy liability. So the bank smiles, hands you a form, and sends you on your way holding a live financial grenade with the pin already pulled. The suits want me to tell you this is not financial or legal advice. Fine. Consider it a survival guide for a system that was designed without a single thought given to protecting your money from threats you never saw coming. Consult an estate planning attorney, consult a financial advisor, but do it now, not after the account is frozen. The time to act is right now, while everything is calm, while nobody is suing anybody, while nobody's getting divorced, while nobody's filing for bankruptcy. Right now is the only window you have. You now possess the elite knowledge to beat the joint custody trap, but knowledge without execution is just watching your money burn in slow motion. Here is your 3-step action plan, and I want you to execute this within the next 72 hours. Step 1. Call every bank where your children are listed as joint owners on your accounts. Ask for a complete list of every account that has a joint owner. Write down the account numbers, the names on the accounts, and the balances. You need to know exactly how exposed you are before you can fix anything. Step 2. Schedule an appointment with an estate planning attorney in your state. Tell the attorney you need a revocable living trust and a durable power of attorney. Tell them you want to retitle your bank accounts into the trust and remove your children as joint owners while granting them agency through the POA. A competent attorney will handle this in 1 or 2 appointments. Step 3. Follow up with your banks after the trust is established. Retitle the accounts into the name of the trust. Provide the bank with a copy of the durable power of attorney. Confirm that your child is listed as an authorized agent, not an owner. Get written confirmation from the bank that the account titling has been changed. That is it. 3 steps, 72 hours, $1,000 or less, and you have just built a legal firewall around your retirement that no creditor, no divorce attorney, no bankruptcy trustee, and no judge can penetrate. The banks will not tell you this. The financial media will not have cover it. The only people who know about this strategy are estate planning attorneys, who charge for the knowledge and wealthy families who have used it for generations. I am trying to level that playing field. Are you calling the bank? Are you calling the attorney? Are you having the conversation with your kids? I want to hear it. Your field report might be the thing that convinces the next person watching this video to finally take action.